You won't believe this. We're back again here at allpointstv.com, and we are glad to see you out there ready to have another exciting program. We're paid to say these things. we're gonna say we have an exciting program, whether we have an exciting program or not. We hope you learn something though, and I think you will. I'm going to do a couple of things here today on the program. This is on President's Day. And I'm very glad to have acknowledgement of our great president. Really, that would be George Washington. Now, you can add some of the names to the list of presidents, of course. We've had, let's see here, we are now, this is 46. Trump was 45. Obama was 44, 43. George W. Bush. And going back into time, and we arrived at the greatest president this country has produced, and that is without any question, without any peer, the great, the fabulous, the fantastic George Washington, the first president of the United States, who carved the mold etched the mold into the presidency by just standing resolutely for a person above the pale who was not interested in being a king. And because of that defining aspect of his presidency, we have a president now that is under the color of law, as all of the office holders of the United States are. And they keep saying nobody's above the law, and it's intended that way by the framers. I'm not so sure that it always plays out that way, because we have a lot of persons that do not intend to follow the Constitution of the United States, and those who are claiming to follow it are misinterpreting the document. So on President's Day, what we're going to do here is to go back to something that we've been talking about for a while, and trying to do it in segments in terms of the impeachment process, because I don't think we are getting what the framers intended by the impeachment, which I think you will admit impeachment is let me say this, it's because it is outside of the normal orbit of the legislative branch of government. That is, say, the impeachment is more of a judicial function, and because it's extraordinary to the legislative branch of government, it is spelled out and particularized in Article 1, which sets up the legislative branch of government. But the way in which it plays out, since impeachment is really a judicial function, they place it in the Article 1, which deals with the legislative branch, and I tell you why they did that. It's because you scholars, are you paying attention here? Because because what you're saying, I ain't buying it. Yeah, I don't know where the training coming from, but I'm telling you where my training comes from, and I don't know where this stuff is coming from. These persons are talking about. I'm going to play. Eventually, I'm going to get to play a segment on Mark Levine's program last night, and he mentioned a book. I don't have this book. I'm gonna have to go and get it, but because it's been brought into the public square now by Mark Levine's program, Life, Liberty, and Levine, that comes on 2 days of the week, Saturday. Well, I say Saturday and Sunday, or Sunday and Saturday, Saturday and Sunday, or Sunday and Saturday, because if you start at the end of the week and you have the program coming on the 17th, that'll be the Saturday program, and then it airs again, a new segment, another program of Mark Levine's show, Life, Liberty, and Levine, comes on Sunday night. It's a Sunday night program that I'm going to play a segment of, the first part of it, and I'm going to take some notes on it because I want to I want to critique what's being said here. Mark Levine says that this person is the most renowned constitutional scholar, so that means he's placing him over. Not that this is a big deal, but places him over Alan Dershowitz and some of the so-called heavyweights today that claim to be constitutional scholars, but I don't think that's really true of them. I think they're lawyers, and they are making a claim here that their training does not allow them to make. Being a constitutional scholar is a very specific scholarship, and that has to be those that are trained and have a degree in the Constitution, and they don't have that. What they have is a legal training, and they have placed their training in the context of the Constitution. That is, say that they are placing their training, which is in the law, as if it's synonymous with the placement of the training in the Constitution. That's a different training. The legal training, the law training that they have is a training in what the Supreme Court has said about the document. And oftentimes what I find in looking at what the court has rendered in its judgments over the years is that if the document, if the Constitution is static, meaning that it is that which is written in the document, either the amendments of the document added to it, or the 7 articles that were in fact originally placed as the document that was drafted and then ratified in 1788, drafted in 1787 and then ratified in 1788. If that is the way we understand the Constitution, then we have to then use the Constitution as a grounding point of what the document represents, rather than those who are speaking to it through an interpretation of it that oftentimes has been in need of being changed, because the document becomes static. Once it's been amended, then that becomes it's still static in that sense that it's added to, but static because that is now the Constitution.
Because like Scalia said, he said it's not a living document; it's a legal document.
Yeah, and we have to get away from this idea that it is. They want to make it a transitory document, so that if they mean by that it allows itself to be amended, that is true. But if they mean by that which is written and added to it can be moved around to mean something different than what it was intended by those who created the language, that's what they mean by the way that it has. This is the Hamiltonian view. Alexander Hamilton having the view that there's both the express language in the Constitution, but behind the express language, there's an implication of what the language stands for and what it means. And so you can import other understandings of it if you could understand the implicit meaning of the words. So there's an express meaning and there's an implied meaning. I'm going to go with that which is expressed, that the writing is what it says it is, and that which is implied is your interpretation of it, because you don't want to be consigned to the tenor of that which is written. I would like to see if you want to change that which is, if you want to amend the Constitution, you have to then place in writing that which is not written. You cannot say that which is written has something beyond the written text. If you want it to be that, and you want to go into all of the implications of the language, you got to then write another additional text to the Constitution so as to amend it through the amendment process. You cannot amend it by these judges deciding they're not going to go by what was actually stated.
In theology, they have the term exegesis, which means you take something from the text, and the eisegesis, which means you insert something into the text. Whereas I think most constitutional scholars, who I'm not conservatives, are saying, well, we'll read the document, take away from that, take this away from that, take not take it away and excise it, but take it out, and that's what we work with. Whereas liberal reads something into it, and I have an issue with that, because you're going to follow documents of any sort. If you really think these have value, why would you want to basically just put your frame, overlay your own imprint on it?
Yeah.
If you really think something's important of it, take it away. Pull that into yourself.
That's right, because everybody can. If you start having it, the implications of it, then everyone sees the implications are different. I would like to be a little bit more on solid ground than that, and that is to say that whatever the language states in explicit terms, and I do think that the framers were very explicit in what they intended, because they kept saying this word "shall" in every part of the Constitution, except in Amendment 10. That's the only one that doesn't have the word "shall" in it. So they were very specific as what they meant, that it shall be this, it shall be that. And they were not giving a lot of wiggle room, because the word "should," if they meant it to intend like a maybe this, maybe that, I think that you will see the word "should" in the document rather than "shall." But when they say, for example, in Articles 1, 2, and 3, that the power of the legislative branch of government in Article 1 shall be invested, they are speaking specifically. And then in Article 2, the executive branch shall be invested in the president. And then the third branch, where it shall be vested in the Supreme Court and inferior courts, as the Congress may see fit to create.
Not like I don't know if you like to use the terms, but normative comes in here. Like normative, it's from a standard. You're appealing to a standard, and ethics and morality and stuff. People want to say that's relative, but it's not. When they want treatment, they want somebody, a standard, to say I can gauge this by. So that's what it is. And see, the liberals have a tendency, whatever we decide at that moment, to decide what it is. It's like basically how many people are screaming for it so we can please them. Okay, well, that's the problem with that goes back to the very core of the between the Democrats and the Democrats always want to insert, this is a democracy, this is us. That you see that the way they try to use those terms,
I
try
do
to
see
connect
it,
themselves to
and
it.
it's very dangerous. I do see that, and it's very dangerous for them to do that, because they are creating language that does not even. The language is not even in the document. I don't know where they can even pretend, less known, state explicitly that the Constitution is a document that calls for democracy. It calls for something that does not even mention in the Constitution of the United States, nor is it mentioned in the Declaration of Independence. And that's, if anyone has read the Federalist Papers, would know why that is that word democracy is not mentioned. You can go and read Federalist Paper 10. Maybe that's the best place to go and read, because they were very James Madison wrote Federalist Paper 10, and you can see in that writing of that paper the tremendous concern that was at the convention in Philadelphia about the danger of what they didn't call it parties at that point, they called it factions, and the danger of the majority faction, because majority faction just do the numbers, get their way, because it's weighted on this side by this number and on the other side by the other numbers, and the ayes have it, and it carries a day without any necessary appeal to that which is legal or authorized by the governing documents. That could be very dangerous if it's just based upon a majoritarian point of view, because majorities can be wrong and often are wrong.
That's in our form of government, the way it's supposed to run as a republic. We're trying to prevent the mob rule, and that's what it can degenerate. Mm-hmm. If you follow the tendency that the Democrats want to go to, it becomes the mob rule, and then there's no standard. You can always say, well, you always maintain the standard because you have it. Right. And that's a problem. It degenerates.
You understand it. Majorities, you mentioned the word mob. It becomes a mob if they can, if majority factions can get their way. Why should they listen to any other voice other than their own voice if they know that by the sheer numbers of the voice in which they speak is the ones that are going to carry the issue, why should they even entertain other voices? And the Constitution is full of examples of where that was seen as very dangerous to put this country on that kind of grounding. You can see, for example, in just the very way in which ratify the Constitution, that that is not what they had in mind, have a majority to decide. If you, for example, look at every way in which the Constitution has only been amended in two different ways, and that is every amendment that we've had except one. That would the exception would be the 21st Amendment. Every other amendment has been passed by a 2/3 vote in the Senate, 2/3 vote in the House, and then after that has occurred, where you have a 2/3 vote, not a majority vote, but 2/3 the members of the House. That would be today with the 435 members of the House. You have 290 of the members of the 435 that would in fact recommend, not to ratify, but to recommend it to the states. And both the House and the Senate will agree by a 2/3 vote in both bodies to then refer it to the states for their consideration, and then the states having a 2/3 voice from both chambers of the Congress will then by a 3/4 vote of the states, 50 states altogether, so 38 of them would have to ratify the recommendation of the House and the Senate. Neither of them can ratify; they can recommend it. So you see the numbers: 50 states. So 26 would be majority. They're not asking for majority. It takes 3/4 of the states, and so 3/4 of the states, or 50 states, would be 38. And you can see they're up in the ante. You can see it even in the fact that you have in impeachment, which I want to get into today a little bit more, because I'm hearing a lot of noise out here about this process, and I'm not sure if I'm explaining it as well as I should, because I know that these scholars tune in this program and they want to critique what I'm saying here. They're not qualified to correct anything I'm saying here. I can assure them of that. And they're not, and they're making a lot of mistakes in what they're saying, as I will show in this clip when I get around to it. But when you look at the number of votes that are needed, you can see that the framers were abhorrent to majorities. But at the same time, the question they had to deal with at the convention was being abhorrent to the danger of majority factions. How do you restrict majorities without taking their voice away? And that was a tremendous part of what they were arguing at the Constitutional Convention. Is that true? You scholars, you agree with that? That they didn't want to come in and then suppress the majority faction as if it had no right to exist. At the same time, in its existence, they recognize the danger of it, because the larger numbers can compel the others to then comply with a verdict of which they disagree, which may not be a verdict that is just. So how do you do that? And they figured out how you do it. You can see it in the way you select the president of the United States. You see, what they did was to require the participation of the lesser voice in the process. And how did they do it? That by having majorities check on majorities. In other words, and this is these people do not understand, is calling for a single majority to elect the president of the United States. That's not, that would be tremendously dangerous. You would talk about having the president elected. That's what they want to do, is get rid of the electoral college. But the electoral college is a brilliant design that is speaking to two things. One is the danger of majorities. At the same time, how do you not compel the majority to go out of business, because majorities do exist. People, they're more on one side of something than on the other. So you don't want to say they have no right to have a majority on anything, but how do you then contain it? And the brilliance of the design is that you fight majorities like you fight fire. You know, you say you fight fire with fire. What they do out there in the when a fire breaks out in places like California, because they're going to say global warming, but it's not because of global warming, but because of the incompetence of the management of the government that does not manage the brushes that are falling down and become kindling wood and fire starters. And by not cleaning that out, you have a lot of debris that, when it gets hot, that debris can catch on fire. But if you clean it out, you'll see that those fires do not start. But they're not doing that because they're not good managers of the resources of the country.
I have a question here. I have a question here, because it's President's Day, and you mentioned Washington already. How involved was Washington, George Washington, in the drafting of the documents, the Constitution?
Yeah, okay, that's a very good question, John, and I'm glad you brought us back to the fact that this is President's Day, and I do want to kind of stay in that zone a little bit. George Washington did not play a verbal role, too much of a verbal role in it, because he was not a delegate. Keep in mind that he's there, having gone there to give some credibility. His name, Washington, was so far up above all the rest of the people of his day. His persona was such he had such a sterling presence on anytime he was present, he was the center of it. So he went to Philadelphia not as a delegate. He went there as a person who was lending credibility to something that had to, in fact, take place if the Union was going to be solidified around a stronger document than had been created in 1781 with the drafting of the Articles of Confederation. So that had not worked. There was too much of a problem with it in terms of how they had severely restricted central power, that was one of the things they wanted to do because of their experience with King George III. So they wanted to restrict it. George Washington doesn't often say anything on the floor, but he is aware of what is going on. He's in all the meetings because by him being there, not being a delegate, but being there, George Washington, by being in Philadelphia, having gone there on his own, they made him the president of what turned into a constitutional convention, and he's involved in all the hearings that are taking place there. He is singly, I won't say that he's singly the only one that is there in all of the meetings. There are a lot of them. There's some of them that are there in all of the meetings, but don't forget 55 will eventually show up, but all of them don't show up at the same time. Some because of the distance, and some because of other things in terms of the delegations being assigned at different points in time, because some didn't want to send delegates and had some hesitancy in doing that. And so they're not all arriving at the same time, but 55 will eventually show up in Philadelphia. Washington is not there to participate in the deliberations as such, because he's not one of the delegates chosen by the 13 states. 12, by the way, one Rhode Island Rhode Island delegation did not send a delegation. So he's not there as a delegate. Washington's there as an observer, and he's made because of what he represented to the nation. That's something that's this is something very powerful to understand on President's Day. Uh, George Washington's persona, his presence, the unifying the unifying aspect of his being anywhere. The people just had, if there was just probably there were 5 people in the world that were great at that time. One of the 5 was George Washington, acknowledged as such throughout the world. Everyone knew that this was greatness with George Washington. We haven't had anything like that since, not on that level. So I put him there.
Okay.
At the top.
See, people nowadays are so used to getting the internet. You know, we got the internet, we got all these various news sources, but I think it's like amazing that from what I've read historically, how many people all over the world. I mean, we're not just talking England, which obviously would know about a lot of the people in England would know about the struggles between the United States, you know, the emerging United States and the, Great Britain, who are their fight for their freedom from. I mean, anyway, but I mean, it was amazing from what I've seen and what I've heard about is how quick the news did, get spread out about the emerging state, republic of, what we call the United States. That was just, and I guess that I would just like to go back and see like how you could ask people about what they would think about this emerging power and the people who were behind it. And of course, you'd have people who are royalists, all countries would back the royals, their aristocracy and all that.
Mhm.
But I mean, that would be an amazing, do you know any writings where people actually expressed their admiration or maybe their opposition to this new world leader, this emerging world leader?
Well, just the people who wrote the books about Washington. You can look at. I think that the biography. What's that book by John Ferling? There's a book out by John Ferling. It's called "The First of Men," and on the front of that book is George Washington's talk. It's a biography of the great George Washington. I think Ferling does probably one of the better jobs. There are some other writers too. Flexner does a very good job, and then Ron Chernoff. That I mean, his Chernoff is a volume writer. So when you get, I would say, start out with some of the books that's not quite as voluminous, because when Chernoff starts to write, he can't stop.
That's the book I have at home. It's really good.
And you see how good how good it
excellent.
is.
I mean, I learned about stuff about George Washington. He had ties to some very significant players in in English history too, though, didn't he? He already had through familiar ties and all that.
Yeah, he did. John, you have a background, so that I would I would say you end with the more complex treatment of this great president. I say that he is our only great president, and we have to stop this placing all these presidents as great. The mold setter, the one that set the mold for the presidency, that's a great thing. And it takes a special person to have put his footprint in the molding of the presidency to such an extent that much of what he did wasn't. It was so powerfully put in place that nobody wanted to break the mold that he had set, and it wasn't broken in terms of some of the things that he had done until 1940 with the election of the second dictator. The election of second dictator in this country, and that was Franklin Delano Roosevelt. You're not going to like me saying this, but the first dictator was Abraham Lincoln. But when you start putting persons on Mount Rushmore, and I know what they were trying to do in 1925, during the time period in which Calvin Coolidge was president, that we had gone through 30 presidents at that point, and they wanted to put. If I'm the person that's actually deciding and making a decision, if I'm going to put more than one president up there, I put them on another side of that mountain. I don't put them up there on the same side as Washington. I have Washington by himself, and then the other 3 that they put along with Washington, I would put them. I'm not sure I would choose those other 3 that they placed up there. I'd have to decide. I'd have to think about that. I don't think that the some of the names, some of the person they put up there are deserving of it based upon what they did as president of the United States. Some of them, like Thomas Jefferson, was up there because what he did in terms of the figure that he cut and carved out for himself as the philosopher through whom the revolution was in fact presented to the world and explained to the world why they were in fact breaking away and doing something different than never been done before. And they explained to the world what they were doing in order to get the world's support. And that's why this document is written. And you read it carefully, you see it's written to mankind. But okay, since it's President's Day, we have more than one president up there. But I would say put Washington up there on the Mount Rushmore in South Dakota by himself. And let's acknowledge that that stands above the pale. And I don't think there's another one of the 45. Say we have 46 presidents, but don't forget Cleveland was president twice in 1884 and 1892, skipping over 88 with Benjamin Harrison and coming back in 92 with Grover Cleveland again, elected in non-consecutive terms. So we really have had 45 different persons out of the 46 presidents. But I acknowledge that we have presidents, obviously one after the other, but you just have to put Washington in the class by himself, because none of them, Washington could have done everything that they did. None of them could have done what Washington did. And that's why I think that we make a mistake in saying, I say, even in President's Day, I think that you have to say, well, okay, President's Day, that's okay, we're gonna put all the presidents together and make a collage of all the presidents and put them into one cubby hole as if all of them are standing there equal, because they're in the same executive branch of government as a single office holder in that branch of government, along with some minions that are chosen in order to accompany the president and make him help inform him in the tasks that are yet within the purview of the executive branch of government. But I think that we have to just think about where in that pantheon of presidents, where do you put George Washington? And I don't put him on the same level as any of the other presidents, because I know that they could not have done what Washington did, and they could, and they did not, and they wouldn't, and no president has had the presence on and the impact upon the nation that George Washington had. I mean, there were people during this time period. John was saying, well, what do people think of his day about Washington? They were very fearful of what would happen to the nation when Washington left.
I just had a realization, and I'd say it's kind of connected, so kind of bear with me, okay? I'm interjecting myself a lot in this program, but okay, the leftists, the communists in this world always try to make assumption that we're like basically people gain power through physical force and they retain it through physical force, and that's a criticism about the way they run, the capitalism, the capitalist system, the American form of government, any kind of government like this. But here's the thing: is even with the impeachment process, which is kind of a sobering reality of understanding that there's a possibility for corruption being set up and they have to remove people from office. Our founders acknowledged. To my knowledge, there was no process for a peaceful, relatively peaceful and more judiciary-minded kind of removal of bad advisors and bad people within the communist system. Basically, it was just a summary execution and followed up with a bullet through the head. I mean, even though we got this headiness, the President's Day has a tendency to kind of nostalgize, the past presidents. Some people have that view. That's, it's a cheery, kind of optimistic viewpoint of we're going to celebrate these men's lives, and a lot of them were corrupt, and some of the skeptics among people are saying that's corrupt and all this stuff. But you look at the fact that the sobering reality, the impeachment process was in our Constitution. When you look at the backdrop of what we're doing, celebrating today, I mean, that was like basically a huge step to realization of what have to deal with reality. And I think that's amazing.
Yeah. When we get to the tape, I'm going to point out a couple of things here that these scholars need to pay more attention to. But I think we have to lay a foundation to understand how even the impeachment process was placed and why it was placed in the document. You want to head off the need to have a revolution. I mean, revolutions are necessary when the voice of the people are not heard. The voices of the people are not heard otherwise, and there's not any other way to get the attention of the government other than to overthrow it. And that speaks to what Thomas Jefferson wrote in the second paragraph of the Declaration of Independence, when he said that that whenever any government becomes destructive of the ends to which it was in fact created, then it's the right of the people to alter that government or to abolish it. And abolish it means to terminate it. So, but you want to hit, but being aware of that, you want to place some way of getting the attention of the office holder, so that you don't have to have these upheavals. You don't want to have upheavals if it can be avoided. But as a last straw, if there's no other outlet in order to get the people's voice to be heard, because we are government of the people, by the people, for the people, or that's what's intended by our documents, then you want to have some way of getting the voice of the people heard by those who take power, and then forget that power is invested in the people and is out of their custodialship, that they in fact lend that sovereignty to the governing body as long as it is beholden to the owners. And I have to tell you this, we are the owners. It's hard to recognize that fact today. But you have to keep in mind what the framers had intended here. Now, I'm going to play this clip because I don't want to get too far gone and I don't get around to doing it and they don't have enough time to talk about it.
Wait, I'll be playing it side by side. You'll be seeing the audience will be seeing you as well as the audio clip, the video clip is. So if you want to stop or anything, I have a ability to stop and then we can resume it after you want to make your point. Okay.
Okay.
All right.
Sounds good to me.
Ready to play? Ready to play?
Ready to play it, John.
All right.
Some of it outright lies, much of it influenced by the Democrat Party and the Democrats within the media and so forth. One of the issues that's been front and center is impeachment. Impeachment of Mayorkas, the Secretary of DHS, a cabinet officer. And what you're hearing, the mantra is you don't impeach somebody based on policy differences, and you don't impeach somebody and open the door wide so that they can then return and impeach you. Of course, we get this mostly from people who brought two outrageous impeachments against Donald Trump that do not stand on the Constitution. So let's dig into this briefly. You'll be more knowledgeable than any legal analyst, any former federal prosecutor, any former federal judge, or anybody else on TV and radio. And I'll tell you why. The greatest book ever written by impeachment was written in 1973 by Raoul Berger. He's deceased, but the former professor at Harvard Law School. And he was acknowledged as such, probably the greatest constitutional scholar of modern times. And he wrote a book, Impeachment, the Constitutional Problems, as I say, in 1973. Stick with me. I just want to give you the basis for this. What exactly is a high crime? You've heard people say impeachment is whatever Congress says it is. No, it's not. It is a constitutional process. Congress has limitations too, but it also has obligations. Well, what do we mean by misdemeanors? Actual crimes? No, high crimes and misdemeanors never meant actual crimes. Listen to this. High crimes and misdemeanors are a category of political crimes against the state. What's a political crime? It's not a criminal code crime against the state. What they meant by that is an attack on the society, on the civil society, on the culture, on the governing system and so forth. Not policy disagreements, not even strong policy disagreements. You take an oath to uphold the Constitution. If you're not upholding the Constitution, if you're rogue and you're violating federal law, that is a political crime against the body politic. That's what they mean by that. Whereas misdemeanors per se describe criminal sanctions for private wrongdoings. He goes on, he says, high crimes and misdemeanors appear to be words of art, confined to impeachments, without roots in the ordinary criminal law, and which, so far as I can discover, he said, had no relation to whether an indictment would lie in the particular circumstances. What the framers of your Constitution did is they spent an enormous amount of time debating impeachment. The first issue they debated the most was this creation of an executive, a presidency, what it would look like, and so forth. And so the second biggest issue was impeachment. They looked at English common law. They went back all the way to the 1300s. They looked at how Parliament handled, quote unquote, impeachment vis-a-vis the king. And they looked at as much historical information as they could in order to come up with the language. They rejected maladministration because they thought, well, if we say maladministration is a basis for impeachment, then Congress will always be able to blackmail a president. So it's not what Congress says it is, it's what the framers of the Constitution meant it to be. What is the language in the Constitution? Article 2, Section 4. The President, Vice President, and all civil officers, that would be cabinet secretaries, of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors, The path by which the framers arrived at this language is traceable in the records of the Constitutional Convention itself through Madison's notes. So we know where this comes from. Some uneasiness apparently was excited by the breadth of the power of impeachment, for there were repeated assurances that impeachment was meant only for, quote, great injuries, quote, great misdemeanors. James Iredell, later on the Supreme Court himself, told the North Carolina Convention that the occasion for its exercise, that is impeachment, will arise from acts of great injury to the community, to the nation. Impeachment, said Governor Johnston in that convention, quote, is a mode of trial pointed out for great misdemeanors against the public, great offenses against society. From James Wilson, Wilson was a great delegate from Pennsylvania, his expression of hope in the Pennsylvania Convention that impeachments, quote, will seldom happen. It is inferable that he, too, was concerned only with serious misconduct. So the question is whether the impeachment of Mayorkas was policy, maladministration, and therefore illegitimate, as the Democrats and the media and 3 Republicans keep telling you, or whether it was legitimate. So let's actually look at the articles of impeachment, which I don't think any news platform has done, and actually read from some of this. Is it policy?
Okay, John, thanks a lot for showing that part there. And almost everything that Mark Levine said is wrong. And this scholar, Berger, I have to get his book. And I will read, I will get a chance to read it. It came out in 73. I wasn't aware of it until it was mentioned last night on Mark Levine's program. But this scholar, Berger, and also these others are all making the same mistake. It's amazing that they skip over the actual language that they are quoting. We will all agree that the Constitution places the impeachment, which is a extra judicial part of the process. The process of the legislative branch of government is really to make the law. But in this case right here, there's an extra judicial angle to what the judicial branch, what the legislative branches of government has to do. And they're not doing a lawmaking function here, they're doing a judicial function here. And therefore, the Constitution assigns that to specifically in that one domain. You see, when you have the separation of powers, if you have something that goes away from that, so that you have these 3 branches of government where the powers invested by the first article, by the first section of the article, Article 1, Section 1 says the legislative power shall be vested in. You see, vested. So that's the function of the legislative branch. But given the fact that we now have the legislative branch playing a judicial function, then that has to be specifically spelled out, because otherwise it would stay within the domain of the separation of the powers, where you have the branches doing different things. Executive branch would do the enforcement, the legislative branch doing the lawmaking, and the judicial branch doing the interpreting of the law, so that we can have a finite understanding what the law requires. Now, the impeachment would be ordinarily a judicial function. I think we'll all agree with that. But let me tell you why it's an exception made in this case. And then I want to make a correction on what Berger says there and what Mark Levine is saying. The reason why the judicial function in terms of impeachment is placed in the legislative branch of government, don't forget now that the executive branch. They're not talking about impeachment in the executive branch. They're saying who the impeachment applies to. Now, the reason why you have the judicial branch excluded from the trial of impeachment is because the judicial branch plays another role. Listen carefully. The judicial branch plays another role in case the process of impeachment is carried out and you have a conviction which removes the separation of powers from the three branches of government. And now we have a legal question. Let's say the president, you have now impeached the president and you convicted the president. Now there's a legal issue that comes up. The impeachment is a political issue. But if you look at Article 1, Section 3, Clause 7, you'll see where the once the impeachment has occurred, then the president, who is protected by the separation of powers otherwise, but once the separation of powers hedge is removed, then the president is open to a trial for a legal matter at that point. Now, if the court has already made a determination to try the president under the judicial branch of government, then that's a double jeopardy issue. So what they did, they separated the political part of the process, and then the legal part of the process is kept in the judicial branch of government. You see, that is what they're doing. They are making sure that the court doesn't, on the one hand, be involved in the trial of the impeachment, and at the same time, you come back to the judicial branch of government where they're trying in the aftermath of the impeachment. They have it as two different processes, one political, and then the court not supposed to be playing a political role. They may think that their role is also political, but their role is not political. They're not supposed to be doing any kind of legislating from the bench, for example. Their job is that of an interpreter of the document. And then in terms of the president now having been convicted, if that happens, then they have the responsibility of hearing then the legal aspect to the question, because the president can be made actionable in a court of law, but it must be a procedure. Now they're arguing in the courtroom, and I heard Trump's lawyers, so I think they're doing a good job. They're going up a mountain upside a person that don't care about what the document calls for, and so they're up against it because the Constitution is not being tethered here. It's being overlooked. They're not following the Constitution in what they're doing with Donald Trump, because in order to do what they're doing, can you imagine having people that have these low positions like Fannie Willis? If you call her Fannie, you're gonna take that as an insult. But you used to have names like Fannie. Everybody would say Fannie. Now it's funny because it's like Fannie Mae and Fannie Lou Hamer. Those kind of names. They kind of got away from that. They look at that as like Aunt your mama. And so now it's not. If you say Fannie, that's like Aunt your mama. So now it's funny, but it's Fani. How do you pronounce that? Okay. Anyway, that's another point. But in having a Fulton County prosecutor, not even the state attorney general, but a Fulton County prosecutor bringing a president to court over a matter when he's president of the United States, that is unconscionable that would happen in this country. And there are 4 different cases against this president when they tried the president politically to remove the umbrella of protection from around him, and they did not do it because they did not bring about conviction in a president, the only one that's ever been impeached 2 times, and they did not remove the hedge from around the president, and they're trying it as if that hedge was removed through the impeachment process, which is mandated by the Constitution, Article 1, Section 3, Clause 7. And if you do not remove that hedge, then that hedge remains. I'm right about that, and there's no scholar in this country qualified to say otherwise. What they're doing is unconstitutional. You cannot bring Trump. I know they're doing it. I'm not talking about I'm not talking about what they're doing. I'm talking about what the Constitution requires.
Look at this and put it back on this. How many wars we currently are involved in? Have they already have their declaration of wars in all these countries? No, but we're still. Aren't they supposed to only do it for a certain period of time before they have to declare it? Otherwise, it has to cease and funding has to cease. We constantly do that stuff.
Yeah.
We allow these people to get away with this stuff.
Yeah, we got to stop this. We got to stop. This is leading to a. This is not going to end well. We don't get back to the document, the governing document. We're going to have all this chaos that we are creating unnecessarily in this country. And if we don't get back to the, I always keep saying get back to the framers, but just look what they wrote. You don't have to do anything additional to it. Just follow the roadmap that they put down. And really, to be honest with you, let's be honest about this. There are no persons in this country right now on the level of those 55 members that met in that room and drafted this document. Not that Chuck, you think Charles Schumer's on that level? Which one of the ones? AOC. You think she's on this level? These persons not qualified to be in the same room with those 55 members that were sent to Philadelphia, and they can forget trying to amend or atone for what they did or didn't do in that room, because they're not on the same level, and we know that from what they're doing right now. Look at the danger that they've led this country down this road. We are at the end of a cliff right now by this false leadership. You don't have to create anything other than what was created in Philadelphia and amend it. Some of the amendments to the document are problematical, and I've gone into that in the past. I'll go into it again a couple of times in the future, no doubt. But as the document was in fact drafted in 1787, we need to go back to those 7 articles and understand what they put and etched in stone. That the original document stands as written, and the impeachment, which is in Article 1, that's another point I want to make. I noticed that it was said in that 10-minute clip or so that impeachment was not for policy differences. It is for policy differences.
Okay, I mean, it's like actually they make it sound like it's more high-minded than it really is. It's meant to actually, if you have policy, let's face it, you have people who are actually working away at trying to destroy what the Constitution and Bill of Rights was all about incrementally. They're being doing by policy, and that would be the best way to oppose them.
Yeah,
through the opposition by removal if their policies went totally against the nature or the spirit of the law.
John, they don't get it when they say that. It's really quite, I don't want to say stupid, but it's really quite stupid to say that it's not over policy differences. The document recognizes that it is about policy differences. That's why they don't get why it says in Article 2, Section 4, they quoted that. They didn't quote it, they read it. But Article 2, Section 4 says the president, vice president, and all civil officers of the United States shall be removed. And how do you skip over that part? Shall be removed. Now it says part here. Shall be removed upon impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. They're not talking about impeachment here. They're talking about a process that's all been carried out. And where it's been carried out? In Article 1. Impeachment is not an Article 2 provision, is an Article 1 provision. You can look at the geography and see that, because impeachment is spelled out in Article 1. Article 1, Section 2, Clause 5, Article 1, Section 3, Clause 6, and Article 1, Section 3, Clause 7. Now, what is Article 2, Section 4 doing? They love to go there, but they need to go there and understand why that is there. Why is Article 2, Section 4 laying out who is subjected to the impeachment process? Good question. Here's the answer. The reason why you have Article 2, Section 4 spelling out who the persons are, who are the office holders that are subject to impeachment: the president, the vice president, and all civil officers of the United States. shall be removed from office upon impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. Taking that and extrapolating it backward to Article 1, then, those that are impeached for reasons that other than treason, bribery, and other high crimes and misdemeanors are not subject to removal from office, because the provision in Article 2 is not an impeachment provision, is a removal provision. And that's what they miss. Article 2 is not talking about impeachment. The impeachment that's mentioned in Article 2, Section 4 is talking about something that's already occurred. The president, the vice president, and all civil officers of the United States shall be removed from office based upon impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. So the impeachment has already occurred. Now, the question is, who does it apply to? It applies to the president, it applies to the vice president. And why is it found in Article 2? Because the civil office holders are all appointed by the President of the United States. And they are the members of the Supreme Court. It's your ambassadors, they're subject to the impeachment process. And members of, did I say members of the Supreme Court? Also the President's cabinet. Those are your civil office holders. Now, it does not then particularize the members of the House and the Senate. And we made a mistake in that regard in 1797, when William Blount, a senator from, at that point, he was a senator from Tennessee, he had gone to the convention as a delegate of North Carolina. But now Tennessee is one of the additional states that in 1797, we now have 16 states in the Union out of the 11, out of the original 13. We've added 3 different states by the time. And now William Blount is the senator from Tennessee. I can understand how they would be confused about the impeachment process, thinking you can impeach a senator, and they put him on trial in the Senate. After having impeached him in the House, put him on trial, he resigned before the verdict could be issued against him, and so on and so forth. Ran for office on the state level. But you read that when you read about it today, you read about what they say that when you ask the question, can a senator be impeached? They'll point Blunt and say yes, because Blunt was impeached. Let me say this: Blunt was impeached inappropriately. You cannot impeach a member of the House and the Senate. That would be inappropriate, because the ones that are laying out the criteria for the process were saying what should happen to those specific office holders. They are laying it out as to who those persons are. Now, they were not excusing themselves from being accountable, but they put that in the domain of each of the 2 branches of the Congress. And thank you, John. And they were saying here, for example, in Article 1, Section 5, Clause 2, not Article 1, Section 2, Clause 5, but Article 1, Section 5, Clause 2, they're saying that the House shall have the authority to chastise his members up to and including the expulsion of his members by a 2/3 vote. So the House takes care of its business. And in Article 1, Section 3, you have the Senate being able to take care of its business, but they don't subject them to the impeachment process. And why is that? Because the impeachment process says the president, vice president, and all civil officers of the United States shall be removed from office upon impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. And you don't see the senators mentioned in that. Why aren't they not mentioning that? Because they're not civil office holders of the United States. That's what needs to be understood. They are sent there as the watchdogs of the federal government on behalf of the states. You see, we still have a reticence about relinquishing power to the federal government. They're not to be empowered without accountability. So as to hold them accountable, the state sent their representatives to the state, to the national capital as a overseer as a branch that would, as a body that would represent the states in overseeing the machinations of the federal government, which could not and should not be trusted to carry out the particulars based on just the distance alone of how far the federal government is from the states. And that's just during the corridor in which they were up and down the eastern seaboard. But now look how expansive it is. Look how much distance there is. You just cannot believe they would have the same assurances of representing the states as the states would have. So states sent their representatives to the central government as their watchdogs, and they're watching over the government in the name of the in the name of the framers, first of all, but in the name of the states, so as to keep the government, real, keep it accountable to those that are its masters, and that's the states, by the way, because the states created the federal government. We forget that as well. So this idea that we have to get away from this idea that the federal government is a provincial head of the states. The states are beholden. The federal government is beholden to the states. They are the daughters. It is the daughter or the son of the states, created by the states, and therefore beholden to the states. And the states were there with the representatives in the House and Senate as watchdogs for that purpose. That's why they're not impeached. They have to. They assign their power to be disciplined by each body having its own disciplinary procedure for disciplining its members, up to and including expulsion of those members, but not through the process of the president, vice president, also the United States. That's a different process altogether. Impeachment is for those officers mentioned in Article 2, Section 4. I got it all in, can't believe it, and just want you to understand that that's what we are doing today, celebrating number one, George Washington, and all the presidents and all the president's men. But don't forget that standing above them all is this tall, towering figure, the first president of the United States, the unconquerable George Washington. Okay, that's it for today. Hope you got some out of it, and hope you'll follow your dream, because if you don't follow your dream, you'll never know what's on the other side of the rainbow.